Lord, the question is whether the governor is bound by act, aid and advice of the Council of Ministers, my lord. Lord, 163, I have read, my lord. I'll read the first part, 163.1, so that, my lord, for just immediate reference, there shall be a council of ministers with the chief minister at the head to aid and advise the governor in exercise of his functions, except insofar as he is by or under this constitution required to exercise his discretion or any of them in his discretion. Correct, my lords? So functions can be discretional, based on discretion, or as per aid and advice. My lord, what is the demarcation? That is the question, my lord, before your lordships, my lord. My lord, here, minimum, my lord, I'll skip what is not relevant, but the minimum constituent assembly debate, my lord, which is relevant for your lordships to consider the question, my lord, is at page 187 bottom. Lord, Mr. Kamath objected this discretion and it was answered by Mahavir Tyagi. Lord, please have a look at Mr. Kamath's objection. When you, sir, raised a very important issue the other day, Dr. Ambedkar clarified this clause by saying that the president is bound to accept the advice of his ministers in exercise of all his functions. But here, Article 143 vests certain discretionary powers in the governor. And to me, it seems that even as it was bad enough. But now, after having amended Article 131 regarding election of the governor and accepted nominated governors, it would be wrong in principle and contrary to tenets of principle of constitutional government which you are going to build up in this country. It would be wrong, I say, to invest a governor with these additional powers, namely discretionary powers. I feel that no departure from the principle of constitutional government should be favored except for reasons of emergency, and these discretionary powers must be done away with. I hope this amendment of mine will commend itself to the House. Then, my lord, this argument is responded to by Sri Mahavir Tyagi, lord, which is here. I beg to differ from my honorable radical friends, Mr. Kamath and Professor Shibban Lal Saxena. And I think the more powers are given to provinces, the stiffer must be the guardianship and control of the central in the exercise of those powers. That, in my view, we have now given up the idea, the old idea of creating autonomous states, and are now keeping a reserve of powers in the center, and we are going to have nominated governors. Those governors are not to be there for nothing. After all, we have to see that the policy of the center is carried out. We have to keep the state linked together, and the governor is the agent, or rather, he is the agency which will press for and guard the central policy. In fact, our previous conception has now been changed altogether. The whole body politic of a country is affected and influenced by the policy of the center. Take, for instance, subjects like defense involving questions of peace or war, of a relationship with foreign countries, of our commercial relations, exports and imports. All these are subjects which affect the whole body politic, and the provinces cannot remain unaffected. They cannot be let free of the policy of the center. The policy which is evoked in the center should be followed by all the states, and if the governors were to be in the hands of provincial ministries, then there will be various policies in various provinces, and the policy of each province shall be as unstable as the ministry. For there would be ministries of various types having different party levels and different programs to follow. Their policies must differ from one another. It will therefore be all the more necessary that there must be coordination of programs and policies between the state and the central government. The governor, being the agency of the center, is the only guarantee to integrate various provinces or the states. The central government also expresses its thought, itself through the provincial states, Along with their own administration, they have also to function on behalf of the central government. A governor shall act as the agency of the center and we'll see that central policy is sincerely carried out. Therefore, the governor's discretionary power should not be interfered with. Democratic trends are like a wild beast. Say what you will. Democracy goes by the whims and fancies of parties and the masses. There must be some such machinery which will keep this wild beast under control. I do not deprecate democracy. Democracy must have its way, but do not let it degenerate into chaos. Moreover, the state governments may not be quite consistent in their own policies. Governments may change after months or years, with them will change their policies. The governors may change too, but the policy and instructions given by the center to the governors will remain practically unchanged. The more the powers given to the states, the more vigilant must be the control. The governor must remain as the guardian of the central policy on one side and constitution on the other. His powers, therefore, should not be interfered with. He is not for nothing. He is not just a showpiece. My lord, thereafter, your lordships may kindly turn the page, my lord. Pandit Thakur Das Bhargav, my lord, continues the discussion. Sir, I beg to propose the amendment of oppose the amendment of Mr. Kamath. Under Article 143, the governor shall be and in the exercise of his functions by the Council of Ministers. It is clear so far. मुझे देना ये कुछ कट गया है मेरा. Article 143, governor shall be aided in the exercise of his functions by a council of ministers. It is clear so far. I gave notice of an amendment which appears on the order page at so and so, which I have not moved. In that amendment, I have suggested that the governor will be bound to accept the advice of his ministers on all matters except those which are under this constitution required to be exercised by him in his discretion. My submission is that it is wrong to say that governor shall be a dummy or an automation. As a matter of fact, according to me, the governor shall exercise very wide powers and very significant powers too. If we look at Article 144, it says the governor's ministers shall be appointed by him and shall hold office during his pleasure. So he has the power to appoint his ministers, but when the ministers are not in existence, who shall advise him in discharge of his functions? There can be a vacuum. One ministry goes, another has not been installed. In that context,
whenever there is a president's rule,
yes,
there are advisors to the governor.
Correct, they're appointed by the center. But can we read further?
In the vacuum also, normally if one CM resigns, or if he loses the majority till the new CM takes, he acts as a caretaker chief minister.
No, sir. Kindly, my lord, have a look at this one. Suppose, my lord, the tenure has gone. The governor tenure doesn't go. The new election takes place. It is considered. And it is considered subsequently in judgments also. My lord, 7-judge judgment, my lord, considers this aspect. Then again, when the governor calls upon the leader of a party for the choice of ministers, after a previous ministry has been dissolved, in that case, there will be no ministry in existence, and who will be there to advise him? Therefore, he will be exercising his functions in his discretion. It is wrong to assume that the governor will not be charged with any function which he will exercise in his discretion. Article 175 and 188 are other articles which give him certain function which he has to exercise in his discretion. That is Article 200 and 188 is emergency powers. My submission is that according to me, the governor shall be a guide, philosopher and friend of the ministry as well as people in general, so that he will exercise certain functions, some of which will be in the nature of unwritten conventions and some will be such as will be expressly conferred by this constitution. He will be a man above party and he will look at the ministry and government from a detached standpoint. he will be able to influence the ministers and members of the legislature in such a manner that the administration will run smoothly. In fact, to say that a person like him is a mere dummy, an automation, or a dignitary without powers is perfectly wrong. It is quite right that so far as our conception of a constitutional governor goes, he will have to accept the advice of his ministers in many matters. But there are many other matters in which the advice will neither be available nor will he be bound to accept that advice. My lord, thereafter, my lord, Dr. Ambedkar's speech, which I have read, my lord, in a different context. So, my lord, I am not reading it here, but he, my lord, substantially echoes the Mahavir Tyagi view and the view of Pandit Thakur Das. Now, my lords, may kindly come to Lord, I have quoted Sirvai, my lord. If your lordship can come to, I will not read it. Page 192. My lord, what are the discretionary powers of the governor and the president? My lord, Sirvai has, my lord, H.M. Sirvai has elaborately dealt with, my lord. I may not read it. Your lordships may kindly read it. It would, my lord, really assist your lordships. Now, please come to, my lord, 194. Lord, these are the judgments on the question of discretion. Lord, please see 188 at the foot of page 194. It is, your lordship gets that? No? It is 194.
What?
194. PDF is 101. Para 188. It is submitted that this honorable court has carved out an exception to the general rule of the aid and advice, which is not expressly stated in the Constitution, however, which is in consonance with the intent of framers of the Constitution of India and also with the scheme of functions and powers of governor provided therein. A reading of the judgments discussed below and other provisions of the Constitution of India would show that inter alia, the following are the exceptions to the general rule of aid and advice, where the Constitution expressly provides for the same. For example, Article so and so, so and so, so and so, where he will not be bound by the aid and advice, and there cannot be any dispute. These are constitutional mandates. B, where the legislative intent emerging from the interpretation of any provision of the Constitution, like the powers under Article 200, 356, or the power to dismiss the government which has lost confidence but refuses to quit, as has been mentioned in the report of Justice M.M. Punchi Commission and have been concurred by a 5-judge bench of this honorable court in Nabam Rabia. I'll read, my lord, very illuminating paragraph of Nabam Rabia, where the constitutional courts specifically declare that certain functions ought to be exercised by the governors on his own. My lord, your lordships have developed this law, my lord, by judicial decision making. Power to summon or prorogue the House of Legislative Assembly under Article 174 when there are strong reasons and material to show that incumbent chief minister and his council of ministers seem to have lost the majority of the House. Then situations or matters where the bias is inherent in the aid and advice of council of ministers, like the case of grant of sanction for prosecution of council of ministers. 197 sanction or section 17 PC Act goes before the governor, my lord, in case of chief minister, then obviously he would not be guided by the aid and advice, and MP judgment, my lord, I'll show that makes it very clear. Now your lordships may kindly see, my lord. This is, my lord, Lord, I'll skip that judgment. Please come to 197, Samsher Singh. Samsher Singh, my lord, is a 7-judge bench judgment. At the outset, I may point out that Samsher Singh's 7-judge bench judgment is taken note of in State of Punjab versus Union of India, but the relevant paragraphs appears to have missed. It doesn't take care of the relevant paragraphs. I can, my lord, make that statement, my lord. If it is challenged, my lord, we can show it from the, it's not there, my lord. I can't, my lord, in state of Punjab versus Union of India, the three-judge bench, my lord, 2024 judgment, takes note of Shamsher Singh, but it has escaped the attention of the bench of these two paragraphs, which according to me is the real law of the. Lord, your lordships would find, my lord, that judgment at page 11669. Just put a note, my lord. That judgment, my lord, volume 5.29, judgment starts at page 11660,
Punjab volume,
volume 5.29, at page, it starts at page 11660. Shamsher Singh is cited at para 16,
para 16.
16, at page 11669.
1 minute.
Not only two paragraphs are noticed. The lordships may come to 11669.
Yeah.
My Lord Justice Narasimha has, my lord. Para 16, my lords have. My Lord the Chief Justice.
Does it start from 11660?
It starts from 11660, but I am at 11669, where Shamsher Singh is noted. These principles have been well established, your lordship gets, my lord, since the decision in Shamsher Singh versus State of Punjab, where this honorable court held, under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on the aid and advice of his council of ministers, save in spheres where the governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of sovereign is considered by the practical rule that Crown must find advisers to bear responsibility for his action. Those advisers must have the confidence of House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. My lord, these paras are quoted. What, my lord, your lordships have, my lord Justice Suryakant has the right copy, my lord, I believe.
This appears to be.
I thought so, my lord. It, my lord, volume Roman 5, 29.
From Allahabad, there's nothing there. 11,670 पेज खोलिए.
My lord, can I give my copy for immediate reference, my lord?
यानी मिल गए.
State of Punjab versus governor.
No, like, yes, go to
My lord, 11669,
paragraph 16.
paragraph 16, my lord, I'm grateful. My lord, where
Shamsher Singh.
Shamsher Singh is noted, para 28 and 32 are quoted, my lord, which I read. May I reread it, my lords? Or may I my lord, read them again?
Yes.
Yes. Under the cabinet system of government as embodied in our constitution, the governor is the constitutional or formal head of the state, and he exercises all his powers and functions conferred on him by or under the constitution on aid and advice of his council of ministers, save in spheres where governor is required by or under the constitution to exercise his function in his discretion. It is a fundamental principle of English constitutional law that ministers must accept responsibility for every executive act. In England, the sovereign never acts on his own responsibility. The power of the sovereign is considered by the practical rule that the crown must find advisers to bear responsibility for his action. Those advisers must have confidence of the House of Commons. This rule of English constitutional law is incorporated in our constitution. The Indian constitution envisages a parliamentary and responsible form of government at the center and in the states, and not a presidential form of government. The powers of the governor as the constitutional head are not different. Well, these two paras are quoted. What is missed from Samsher Singh is in my written submission at page 197. Well, these two paragraphs. Your lordships are at page.
Other than those two paragraphs, nothing else is referred of some shade thing.
And this is what I'm now showing.
54 and 55 you want to.
And it's a Samsher Singh is 7 judgments.
66.
Well, please see para 54 and 56. The provisions of the Constitution, your lordship gets one. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which reference has been made. To illustrate, Article 239(2) states that where a governor is appointed an administrator of an adjoining union territory, he shall exercise his functions as such administrator independently of his council of ministers. The other articles which speak of discretion of the governor are para so-and-so, para so-and-so, so-and-so 6th schedule and article so-and-so, so-and-so. The discretion conferred on the governor means that as the constitutional or formal head of the state, the power is vested in him. In this connection, reference may be made to Article 356, which states that the governor can send a report to the president that a situation has arisen in which the government of the state cannot be carried on in accordance with provisions of the Constitution. Again, Article 200 requires the governor to reserve for consideration any bill which, in his opinion, if it became law, would so derogate from the powers of the High Court as to endanger the position which the High Court is designed to fulfill under the Constitution. Now, 55. In making a report under Article 356, the governor will be justified in exercising his discretion, even against the aid and advice of the Council of Ministers. The reason is that the failure of constitutional machinery may be because of the conduct of the Council of Ministers. This discretionary power is given to the governor to enable him to report to the president, who, however, must act on the aid and advice of Council of Ministers of the center in all matters. In this context, Article 163(2) is explicable that the decision of the governor in his discretion shall be final and the validity shall not be called in question. The action taken by the president on such a report is a different matter. The president acts on aid and advice of Council of Ministers. In other matters where the governor acts in his discretion, he will act in harmony with his Council of Ministers. The Constitution does not aim at providing a parallel administration within the state by allowing the governor to go against the advice of Council of Ministers. Now, please see 56 is important. Similarly, Article 200 indicates another instance where the governor may act irrespective of any advice from the Council of Ministers. In such matters where the governor is to exercise his discretion, he must discharge his duties to the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. Lord, now I'll come to that, my lord, and my learned friend also will take assist your lordships on that. Lord, in the judgment of Tamil Nadu, this is distinguished by the Honorable two-judge bench, my lord, relying upon a concurring opinion in this seven-judge bench judgment, my lord. One paragraph of the concurring judgment, I'll come to that. Now, my lord, next judgment is MP Special Police Establishment Act. Again, my lord, 5 judges, and was not noticed by the state of Punjab judgment. Now, para 11, I'll skip, my lord, the first part. First part gives the facts. What were the facts of that case, my lord, which may not be relevant for the present, but I have put it, my lord, for ready reference. Para 11. Mr. Sorabji submits that even though normally the governor acts on the aid and advice of Council of Ministers, but there can be cases where the governor is, by or under the Constitution, required to exercise his functions or any of them in his discretion. The Constitution of India expressly provides for contingencies, my lord, so and so, so and so, so and so. However, merely because the Constitution of India expressly provides, in some cases, for the governor to act in his discretion, can it be inferred that the governor can so act only where the Constitution expressly so provides? If that were so, then subclause 2 of Article 163 would be redundant. A question whether a matter is or is not a matter in which the governor is required to act in his discretion can only arise in cases where the Constitution has not expressly provided that the governor can act in his discretion. Such a question cannot arise in respect of matters where Constitution expressly provides that the governor is to act in his discretion. Article 163(2) therefore postulates that there can be matters where the governor can act in his discretion even though the Constitution has not expressly so provided. Mr. Sorabji relies on the Samsher Singh versus State of Punjab. A 7-judge bench of this court inter alia considered whether the governor could act by personally applying his mind and or whether under all circumstances he must act only on the aid and advice of councillors ministers. It was inter alia held as follows. My lord, para 54 to 56.
Which you just read.
Which I just read, which, my lord, appears to have escaped the attention of the bench in State of Punjab. Now, my lord, again, MP judgment again starts. Thus, as rightly pointed out by Mr. Sorabji, a 7-judge bench of this court has already held that the normal rule is that the governor acts on the aid and advice of Council of Ministers and not independently or contrary to it. But there are exceptions under which the governor can act in his own discretion. Some of the exceptions are as set out here in above. It is, however, clarified that the exceptions mentioned in the judgment are not exhaustive. It is also recognized that the concept of governor acting in his discretion or exercising independent judgment is not alien to the Constitution. It is recognized that there may be situations where, by reason of peril to democracy or democratic principles, an action may be compelled which from its very nature not amenable to ministerial advice. Such a situation may be where bias is inherent and or manifest in the advice of the Council of Ministers. My lord, this judgment of MP, 5-judge bench, my lord, is, my lord, not considered, my lord. It has escaped the attention. Now I come to, my lord, most important judgment, Nabam Rebia, a relatively recent judgment, my lord, Arunachal Pradesh, my lord, issue. Lord, I must say, this is again, my lord, not, my lord, it has escaped the attention of the bench in State of Punjab. It was placed for consideration in Tamil Nadu judgment, my lord, but it quotes some paragraphs, Tamil Nadu judgment, but para which I am going to read, my lord, again has missed the attention of the bench, my lord. Kindly see, my lord. Similarly, in Nabam Rebia, para 151, 152, the Honorable Court referred to the Punchi Commission's formulation that governors' discretionary powers include to give assent or withhold or refer a bill for presidential assent under Article 200 and expressly endorse and adopt it. It was held as under. But 151. The important observation in Justice M.M. Punchi Commission report with reference to Article 163(2) are contained in para 4.5. The relevant extract in the extract of the same is as under. Article 163(2) gives an impression that the governor has a wide, undefined area of discretionary powers even outside situations where the Constitution has expressly provided for it. Such an impression needs to be dispelled. The Commission is of the view that the scope of discretionary powers under Article 163(2) has to be narrowly construed, effectively dispelling the apprehension, if any, that the so-called discretionary powers extends to all the functions that the governor is empowered under the Constitution. Article 163 does not give the governor a general discretionary power to act against or without the advice of his council of ministers. In fact, the area for exercise of discretion is limited, and even in his limited area, his choice of action should not appear to be arbitrary or fanciful. It must be a choice dictated by reason, activated by good faith, and tempered by caution. The governor's discretionary power are the following: to give assent, this is Punchi Commission. The governor's discretionary powers are the following: to give assent or withhold or refer a bill for presidential assent under Article 200, the appointment of chief minister under Article 164, dismissal of government which has lost confidence but refuses to quit since the so-and-so, so-and-so, so-and-so. Now, my lord, Nabam Rebia, 5-judge bench again, my lord, quotes with approval this observations and says, we are of the considered view that the inferences drawn in the judgment MC Punchi Commission report extracted herein above are in consonance with the scheme of the functions and powers assigned to the governor with reference to the executive and legislative functioning of the state, and more particularly with reference to the interpretation of Article 163. We endorse and adopt the same as a correct expression of constitutional interpretation with reference to the issue under consideration. My lord, if your lordships were to see, my lord, how this is dealt with in Tamil Nadu, volume 31, my lords. This is 151, 152. Lord, this Nabam Rebia is missed in Punjab judgment. Tamil Nadu judgment takes note of it. But please see, my lord, so far as these two paragraphs are concerned, my lord, that again has missed the attention of the bench, my lord, in Tamil Nadu, my lords. My lord, page 12432, para 301. Lordship gets, my lord. 11301. Lord, another constitution bench of this court in Nabam Rebia had the occasion, my lord. Thereafter,
One page number?
I'm sorry, 12432.
Yes. Paragraph
12432.
Yes.
Para 301. Another constitution bench of this court in Nabam Rebia. Nabam Rebia is, my lord, taken note of. Then, my lord, the honorable court is pleased to quote 140, para 147.1, 147.2, 148, 149, and at page 12435, Lord, possibly misses 151 and 152, which I read, and comes to 154. And this discussion in Tamil Nadu is directly while dealing with the question of discretion. These two paragraphs, my lord, since, my lord, it escaped the attention of the two-judge bench, my lord, I am placing for your lordship's consideration. Now, my lord, I come to the next judgment, that is B.K. Pavitra. But this is two-judge bench judgment, which is declared.
Just 1 minute. Come back to page 12432. The Tamil Nadu judgment refers to paragraphs 147, 148, 149, and then it jumps to paragraph 154. 151 and 152 are left out.
That's what I submitted, my lord, with profound respect. That two paragraphs seems to have escaped the attention of the bench, my lord. Because from 149, it directly goes to 154. And in my submission, the real law is laid down in 151 and 152. And this is, my lord, while discussing discretion, the point which I am arguing, my lord, whether in all cases aid and advice is binding or there is a room for discretion. Lord, now please come to page 200 of my submissions, my lord. BK Pavitra judgment. Lord, this issue was squarely there.
Can you
This-
read 154 with Tamil Nadu refers to underline
only a
which
minute.
comes after 152. They same very page. 154 of Tamil Nadu follows 151 and 152.
Please maintain that though.
Lord,
other paragraphs are
154 is Nabam.
वो दो missing.
चार पैराग्राफ
बाद में
151 and 150.
Lord, 154 is slightly different from 151, 150. It is not slightly, but not substantially. Lord, now kindly come to BK Pavitra. Page 200. This is, of course, a two-judge bench judgment, but it is declared per incurium. And I'm not repeating the argument, my lord, but this itself was sufficient enough for a reference under 145.3. Lord, apropos your lordship's very correct, my lord, the proposition, my lord, the Chief Justice says at the outset that in every matter we are not supposed to look at 145.3.
But as far as justiciability is concerned, paragraph 155.5, Evam Bibia.
Yes, ma'am. But 155 will have to be read in context of 151,
Yes,
150.
but then even you read 155.5.
Fifthly,
Page 1, 2,
the underlined portion, highlighted part. Fifthly, the submission advanced on behalf of the respondents that the exercise of discretion under Article 162 is final and beyond the scope of judicial review cannot be accepted. Firstly, because we have rejected the submission, but this is on judicial review, not on discretion. Rejected advance by the respondent that the scope and extent of discretion vested with the governor has to be ascertained from Article 163(2) on the basis whereof the submission was canvassed. And secondly, any discretion exercised beyond the governor's jurisdictional authority would certainly be subject to judicial review. It was on judicial review. And it is, if it is beyond, but not obviously, if governor.
According to you, under 200, he has an ample discretion.
That's
And
what
therefore-
Nabam Rebia says, my lord. And my lord, that's my contention. He has ample discretion, my lord. Situations may differ. The instances which are given in all the judgments are illustrative, not exhaustive. But they say that it is wrong to say that in every matter, like precedent, he is bound in every matter by aid and advice of the Council of Ministers. Samshay Singh also, my lord, 7-judge bench says that there are discretionary areas, including Article 200. Specifically, Article 200, every constitution bench mentions. That was precisely, my lord, the question in Tamil Nadu. I'm not, my lord, deviating from this point, but, my lord, just to, my lord, kind of respectfully respond, my lords have very rightly said that in every case, it's not necessary that the court would examine 145.3. A bail petition comes, it would involve Article 21, but it won't become a constitutional interpretation question that it has to be referred to the larger bench. But this was a case where only issue was constitutional interpretation. Facts were not, my lord, much in dispute. Anyway, my lord, leave it at that. Please come to BK Pavitra. My lord, para 66. This is, my lord, declared to be per incurium by the two-judge bench, my lord, in Tamil Nadu. I'll show, my lord, that. Where a bill is not a money bill, your lordship gets. Where a bill is not a money bill, the governor may return the bill for reconsideration upon which the House or Houses, as the case may be, will reconsider the desirability of introducing the amendments which the Governor has recommended. If the bill is passed again by the House or Houses, as the case may be, the Governor cannot thereafter withhold assent. The second proviso to Article 200 stipulates that the Governor must not assent to the bill but necessarily reserve it for the consideration of the President if the bill, upon being enacted, would derogate from the powers of the High Court in a manner that endangers its position under the Constitution. Save and except for bills falling within the description contained in the second proviso, where the Governor must reserve the bill for consideration of the President, a discretion is conferred upon the Governor to follow one of the courses of action enunciated in substantive part of Article 200. Aside from bills which are covered by the second proviso, where the Governor is obliged to reserve the bill for consideration of the President, the substantive part of Article 200 does not indicate specifically the circumstances in which the Governor may reserve a bill for consideration of the President. The Constitution has entrusted this discretion to the Governor. The nature and scope of the discretionary power of the Governor to act independent of or contrary to aid and advice of Council of Ministers under Article 163 was discussed in Nabam Rebia versus so-and-so. Where my lord 154 is quoted, no, I've read, I'll skip that. Then para 67 of BK Pavitra. The framers carefully eschewed defining the circumstances in which the Governor may reserve a bill for a consideration of the President. They did not give instances, they left it open-ended. By its very nature, the conferment of power cannot be confined to specific categories. Exigencies may arise in the working of the Constitution which justify a recourse to the power of reserving a bill for the consideration of the President. They cannot be foreseen with the vision of a soothsayer. The power having been conferred upon a constitutional functionary, it is conditioned by the expectation that it would be exercised upon careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. The entrustment of a constitutional discretion to the Governor is premised on the trust that the exercise of authority would be governed by constitutional statesmanship. In a federal structure, the conferment of this constitutional discretion is not intended to thwart democratic federalism. The state legislatures represent the popular will to those who elect their representatives. They are the collective embodiment of the will. The act of reserving a bill for assent of the President must be undertaken upon careful reflection, upon a doubt being entertained by the Governor about the constitutional legitimacy of the bill which has been passed. Article 200 contains the source of the constitutional power which is conferred upon the Governor to reserve a bill for consideration of the President. Article 254(2) is an illustration of the constitutional authority of the Governor to My Lord Justice Suryakant has the same 5 minutes. Article 200 contains the source of the constitutional power which is conferred upon the Governor to reserve a bill for consideration of the President. Article 254(2) is an illustration of the constitutional authority of the Governor to reserve a law enacted by the state legislature for consideration of the President in a specified situation where it is repugnant to an existing law or to a parliamentary legislation on a matter falling in the concurrent list. Eventually, which is specified in Article 254(2), does not exhaust the ambit of the power entrusted to the Governor under Article 200 to reserve a bill for consideration of the President. Apart from repugnancy in matters falling in the concurrent list between state and the parliamentary legislation, a Governor may have sound constitutional reasons to reserve a bill for consideration of the President. Apart from the repugnancy issue, Article 200 in its second proviso mandates that a bill which derogates from the powers of the High Court must be reserved for consideration of the President. Apart from bills which fall within the description set out in the second proviso, the Governor may legitimately refer a bill for consideration of the President upon entertaining a legitimate doubt about the validity of the laws. By its very nature, it would not be possible for this court to reflect upon the situations in which the power under Article 200 can be exercised. This was noticed in the judgment of this court in Hext. In Hext, so and so. Lord, I'm sorry, I'm always confused with this pronunciation. Excluding it from judicial scrutiny, the court withheld. My Lord, I have read this, my Lord, when I read Hext, my Lord, so I'll not. Uh, hmm? Yes, my Lord. But I'm not reading it, my Lords. Now, your Lordships, my Lord, kindly come to, my Lord, this point is over, my Lord. My Lord, there are some issues, my Lord, which we have divided with a view to save time, my Lord. My learned friend also would assist your Lordships, would supplement without, my Lord, repeating, my Lord. They would be able to more and effectively assist your Lordships. My Lord, kindly come to 204. But, yeah,
In a louder manner.
yes, sir.
Both of them.
No, anything remains, no, not survives. Yes, sir.
We'll have to put off the wife.
Yeah, yeah. There was an interesting incident. I'll not share it here. My Lord Justice Narasimha, me and my colleague, my Lord, we went to Pune for arguing one matter, my Lord. Before NGT Pune, my Lord. But I'll some other day, not in the matter. My Lord, question number, page 204.
Why are you unnecessarily thinking about anxiety?
No.
Either you should have not mentioned.
Now we have
Or
mentioned
if you have mentioned, you mention it fully.
Yes.
Unless it is not embarrassing to my learned brother.
No. It's not, my Lord, embarrassing to his.
So what happened in NGT Pune?
Lord, I'll just say with his permission.
Not let you proceed.
No, I'll say that.
You
with
can't
his-
stop halfway.
Lord, I'll say that with permission of my learned friend and with an apology. It's not intended to insult. Lord, NGT Pune is a small courtroom. It's like a little slightly bigger bedroom. It's in a government building. My learned friend, all of us were on the same side. He was arguing, Lord, in his own way. Justice Kingaonkar.
In his own volume.
Yes. Justice Kingaonkar was presiding over the bench.
Yes.
So at some stage, he did like this. So my learned friend understood that the honorable judge is unable to cope up with my speed. So he continued the same volume. But reduced the speed. Then I requested my learned friend that the trouble is with the volume, not the speed. And the judge complimented me by saying that, thank you, you prevented Punjab Mail. Sorry, but he's like my brother, my Lord. I can take this liberty. My Lord, page 204. Lord, this is, my Lord, something very, very serious, and your Lordships may take this, my Lord, into consideration. One constitutional organ prescribing time limits for another constitutional organ. Lord, I can, my Lord, I have no quarrel and I will never argue, my Lord, and I'll pitch my argument that statutory functionaries can be bound by a time limit. The deputy collector deciding to grant or withhold non-agricultural permission. But would it apply to constitutional functionaries which are coordinate constitutional functionaries? My Lord, these are the two questions, my Lord, which are question number 5 and question number 7. I apologize. My Lord, I have incorporated, my Lord, the debate which I have already read. In one line, I may just refresh your Lordship's memory. Wherever time limit was stipulated at the time of drafting of the Constitution, the time limit was deleted. And in that very provision, wherever time limit was required, time limit is added. So constitutional framers are very conscious of the fact that some functions need a time-bound exercise of power and some functions needs a kind of leeway, and we may not bind the constitutional functionaries with the power. My Lord, please come to page 208, and I'm not going to read this, only for your Lordship's assistance at page 209. My Lord, I have compiled the constitutional provisions where constitution itself stipulates the time limit. I'm not reading it. Lord, just Lord, with a view to see that your Lordships gets it, Lord, at one place. Lord, 209, Article 22, Article 62, etc., my Lord, the list goes on till at page 224. Wherever the Constitution has thought it appropriate for the object which that particular provision seeks to achieve, the Constitution provides for a time limit. Wherever the Constitution has, framers have considered. Yes, my Lord, kindly note one more thing. Tamil Nadu judgment, which mandatorily stipulate time limits for the Honorable President and the Honorable Governor, relies upon the report of Punchi Commission and Sarkaria Commission. It itself says at the end, and obviously so, that these are our recommendations and we recommend suitable constitutional amendments. Meaning thereby, the reliance on the report itself, my Lord, in my respectful submission, may not be correct, because Commission does not say that do it by way of a judicial adjudication. It has to be, my Lord, logically. I don't have to stretch this point any further. If a commission is appointed by the central government of the day will consider whether to bring it by way of an amendment or not. But very interestingly, my Lord, a converse situation has arisen. My Lord, in one judgment, which your Lordships would find at page 231, where one organ of the state, namely the legislature, provided for the time limit for another organ of the state, namely the judiciary. Matter went before, my Lord, 7 judges bench. And your Lordships would find the judgment at page 231.
238.
231.
Paragraph
Lord, I'm sorry, my Lord. One fact, my Lord, I missed. Lord, there are judgments which I have cited from page 224 to 231 that even in statutes, court cannot add words, supplement words, or delete words. Lord, the leading
Except
judgment.
causes omissus.
Yes, madam. It is conscious omission. And even if the court were to do it, court can suggest that we recommend or we suggest that the competent legislature may exercise its amending power, either constitutional provision or so. But my Lord, one judgment, which is I'm not reading, page 228. 28 is the judgment, Lord, where my Lord Justice Narasimha was also, my Lord, on the bench. Suprio versus Union of India. Lord, this is a 5-judge bench, but I found, my Lord, that it is not reportable. It has not been reported anywhere, my Lord. So this was that right of LGBT community, my Lord, my Lord, seeking, where, my Lord, the court said that we cannot read words into the statute. My Lord, this judgment remains unreported. Thereafter, there are 2 judgments which relies upon this judgment, and those 2 judgments, my Lord, including electoral bond, they are reported. But this judgment, my Lord, remains unreported. As a matter of fact, that's all. Otherwise, my lord, it's a leading landmark judgment, my lord, laying down several issues of seminal constitutional importance, my lord, not only for the country, but for the society. I leave it at that. My lord, page 231. Page 231, my lord. When, my lord, legislature, my lord, provided for timeline for the judiciary. This is where, my lord, we say the separation of powers, constitutional committee between or amongst three or coordinate organs of the state. In P. Ramchandra Rao versus State of Karnataka, Lord, that is 7 judges, has been held that time limits for criminal trials cannot be prescribed. Lord, your lordships would see, sometimes facts may justify time limit, but justification does not confer jurisdiction. We may come across a situation where we feel that it is fully justified, that some time limit should be done. But if there is no jurisdiction, there is no jurisdiction. Justification can never confer jurisdiction. Kindly see, my lord, what the 7-judge bench is pleased to observe. When one organ fixes time limit for the other, my lord, incidentally here, it's a converse. Legislature fixing it for the judiciary. Para 225, my lord, of this judgment I have quoted. During the course of its judgment, also the Constitution bench made certain observations which need to be extracted and reproduced. But then speedy trial or other expressions conveying the said concept are necessarily relative in nature. Kindly pause here for a minute. There are several considerations: lack of staff, lack of my lord, the burden of cases,
Depending
several
on the case.
considerations.
Depending on case to case, like.
Case to case, some case may take longer, some
Bomb
case
blast case, there might be 200, 300 witnesses.
witnesses. Lord, that is the justification. Lord, why I am pausing here? Lord, in case of decisions of the nature which governor or the president takes, they are polycentric decisions. They are not ticking the boxes that yes, complied with, complied with, complied with. There are they may decide, they may choose to call the governor, choose to call the chief minister. They may take some other consultative process to ensure that there is no impasse, etc., etc. And therefore, there may be several reasons for the delay. One may ask, speedy means how speedy? How long a delay is too long? We do not think it possible to lay down any time schedule for conclusion of criminal proceedings. The nature of offense, the number of accused, the number of witnesses, the workload in the particular court, means of communication, and several other circumstances have to be kept in mind. It is neither advisable nor feasible to draw or prescribe an outer time limit for conclusion of all criminal proceedings. It is not necessary to do so for effectuating the right to speedy trial. We are also not satisfied that without such an outer limit, the right becomes illusory. Even apart from Article 21, courts in this country have been cognizant of undue delay in criminal matters, and whenever there were inordinate delay or whether proceedings were pending, where the proceedings were pending for too long and any further proceedings were deemed to be oppressive and unwarranted, they were put an end by making appropriate orders, prescribing periods of limitation at the end of which the trial would be obliged to terminate the proceedings and necessarily acquit or discharge the accused, and further making such directions applicable to all the cases in the present and for future, amounts to legislation which in our opinion cannot be done by judicial directives and within the arena of judicial lawmaking power available to the constitutional courts, however liberally we may interpret Article 32, 21, 141 and 142 of the Constitution. The dividing line is fine but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacunae and fill the gaps but they cannot entrench upon the field of legislation properly meant for legislature. Binding decisions can be issued for enforcing the law, and appropriate directions may issue, including laying down of timelines or chalking out a calendar for proceedings to follow to redeem the injustice done or for taking care of rights violated in a given case or set of cases, depending on facts brought to the notice of the court. Now, my lord, this court says this, my lord, which generally it reserves its own my lord, domain. This is permissible for the judiciary to do. Legislature cannot. But it may not, like the legislature, enact a provision akin to or on the lines of chapter so-and-so of the Code of Criminal Procedure. So legislature cannot. My lord, here also, I think, my lord, the provision was deemed acquittal or something. My lord, it was judgment of the Supreme Court which put time limits.
Right.
On completion of the trials and the my lord, recently in Allahabad High Court, my lord, judgment also, my lord, where the my lord, that Asian resurfacing judgment that it will have to be decided within 6 months or interim order will be deemed to have been vacated.
That is reviewed now.
Yes.
That is recalled.
That recalled by a 5-judge bench. 5-judge bench. Lord, here the judgment said judiciary's power is untrammeled, Lord, as per all the judgments, that if it is not decided within 6 months, the interim order is deemed to have been vacated. We are also dealing with, my lord, similar situation where it is deemed assent, etc. My lord, I'll come to that.
Outer limit at all. Your question is, isn't there an outer limit? Can the constitutional interpretation be left to a vacuum, creation of a vacuum, a long jump?
My lord, there are two answers.
Jump by, of course, we have had that there is nothing like a pocket veto. Just keep it and don't respond. That's not permissible. But though we can't specify a time limit, but at the same time, there must be some way in which the process works out. Can it be a situation where not acting on a bill which is sent to the governor
My lord, that is,
itself is a full stop, no further, is it?
my lord, I'll answer it.
Where we need your assistance.
Yes, my lord. I'll answer, my lord, in two ways. A, what your lordships very rightly, my lord, feels pained at is a justification for fixing time limit, but will not confer jurisdiction to fix time limits. Number two, if that is so, Lord, we are not flooded with cases where, my lord, such situations have arisen. Lord, there are instances where, Lord, 1 or 2 states have come, my lord, with such situations. If that is the problem, and that may be the problem, the remedy lies with the constitutional framers, my lord, with the parliament. The parliament will have to be done. Your lordships have said time and again in several judgments that in view of this, we request the parliament. Your lordships never direct. Your lordships never direct, coordinate constitutional functionary. Even if the notice goes to a constitutional functionary, your lordship's registry's form is also different. You are called upon to remain present is not there. You are requested to put your appearance because that's the constitutional committee. Lord, your lordships have said in large number of cases that the desirability of the parliament to consider this. But the practical answer, my lord, if I were to, my lord, assist your lordships, is the political answer. Suppose a particular governor is, my lord, sitting over the bill, my lord, there are political solutions. And such solutions are taking place, and my lord, it is not everywhere that state is advised to rush to the Supreme Court. Lord, the chief minister goes and requests the prime minister. Chief minister goes and meets the president. There are delegations which go that this is the bill which is pending. Please talk to the governor. Let him take decision one way or the other. Telephonically, they are sorted out. There is a joint meeting with prime minister, chief minister, and the governor, or the president, chief minister, and the governor, and such impasse is not solved. So that would not confer jurisdiction to lay down a guideline by a judgment. That is the question. That in absence of a constitutionally provided guideline, time limit, can it be read even if there is a justification? And my lord, genuinely, my lord, I'm urging your lordships to consider such issues are arising in every state since last many decades. I'm not talking of this government or that government, but the statesmanship, the political maturity, the political statesmanship, they are at play. They meet the constitutional functionaries at the center. They discuss, debate, because all bills are not contentious bills. They are kept, my lord, for one reason or the other. There is some impasse, some lack of communication. Some clarification might be required, which might be wanting. Then, my lord, they come together and a political solution is found that, all right, if you don't want to do it, refer it to the president will examine. Lord, these are the solutions of the problem. Lord, I'm therefore, my lord, at the cost of making a little unpleasant argument, my lord, saying that every problem in this country may not have solutions, my lord, here. There are problems, my lord, in the country where you must find solutions within the system. This is what your lordships have said in this judgment, that there is a question of delay. Article 21 is affected. People are languishing in jail. But solution will have to be found from within the system. And your lordships are doing a lot from within the system for streamlining, for ensuring that timely trials take place with assistance of the legislature. Now we have, my lord, the legislative provisions that even summons can be served through electronic mode. Even a WhatsApp message is a good service of summons. How responsibilities are fixed for the officers to bring in witnesses, etc. But this is a collaborative exercise. Lord, suppose, my lord, there is a bill passed by the parliament. Kindly, my lord, suppose there is a bill passed by the parliament that people of the country are approaching us that my trial is pending since 30 years, my son is in jail, and it is not being taken up. I am posing a question to myself, my lord, can the executive, maybe the president of India, say that no, I understand there is a problem and therefore your trial is treated to have been terminated. You are deemed to have been acquitted. You have already undergone 30 years. It cannot be done. Justification can never, my lord, hierarchical system that ultimately every organ's decision or conclusion would rest in one organ. There are checks and balances. For example, my lord, legislative act enactment is subject matter of your lordship's judicial review. It's not a hierarchical position, but your lordship's power of judicial review. Any decision taken by the executive, which is not a plenary constitutional power. The executive takes several decisions, my lord. The ministry, my lord, makes a policy. Ministry takes a particular decision. There are several executive functions, administrative functions. They are all subject to judicial review. But when it comes to constitutional plenary powers, more particularly of the nature which are legislative, my lord, justiciability should be denied, my lord. That is my respectful submission, my lord. My lord, on which, my lord, I am placing reliance upon one judgment, Indira Nehru Gandhi versus Raj Narayan. My lord, here your lordships have seen, my lord, a adjudication by the court by an enactment was sought to be, my lord, upturned. Please have a look at, my lord, page 258. My lord, I'm skipping through, my lord, most of the things. I'm paraphrasing it now. My lord, page 258. Para 313, my lords have.
Yes.
My lord, the Chief Justice has. Page 258, para 313.
313.
313, my lord. Indira Nehru Gandhi versus Raj Narayan. Para 577. There is ample evidence in the Constitution itself to indicate that it creates a system of checks and balances by reason of which powers are so distributed that none of three organs is set up, it sets up, can become so predominant as to disable the others from exercising and discharging powers and functions entrusted to them. Though the Constitution does not lay down the principle of separation of powers in all its rigidity, as is the case in United States Constitution, yet, as was found in Ranasinghe case, so-and-so versus so-and-so, the judicial review provided expressly in our Constitution means Article 226 and 32 is one of the features upon which hinges the system of checks and balance. Neither of three constitutionally separate organs of the state can, according to the basic scheme of our Constitution today, leap outside the boundaries of its own constitutionally assigned sphere or orbit of authority into that of the other. This is the logical and natural meaning of the principle of supremacy of the Constitution. But no constitution can survive without a conscious adherence to its fine checks and balances, just as courts ought not to enter into problems entwined in the political thicket. Parliament must also respect the preserve of the courts. The principle of separation of power is a principle of restraint. My lord, it is not a prohibition. It is a principle of restraint. My lord, the very nature of the function at the cost of repetition, my lord, I am respectfully urging is such that it is entwined with political thicket. There may be 50 considerations weighing with the constitutional functionaries, for which your lordships may not have a judicially manageable standard to examine and decide whether it is valid or invalid. My lord, then next judgment, I'll read only the highlighted part, my lord. MP oil extraction versus state of MP. The supremacy of each of three organs of the state, legislature, executive, and judiciary in their respective fields of operation, needs to be emphasized. The power of judicial review of the executive and legislative action must be kept within the bounds of constitutional scheme so that there may not be any occasion to entertain misgivings about the role of judiciary in outstepping its limit by unwarranted judicial activism being very often talked of in these days. So this is 1997 judgment.
Now we are in 25.
Now we are in 2025, my lord, and now again, my lord, this discussion is going on. And my lord, mostly, my lord, your lordship's intervention has been, my lord, for the benefit, but sometimes, my lord, it is believed that it is in the domain of executive. For example, my lord, one of the high court, since I have appeared, my lord, without naming, virtually the COVID management was being monitored, my lord, administered by the high court. And all our officers who were supposed to be working on the ground were sitting in my chamber and we were preparing the status reports. What is the vaccine available? What are the number of companies which manufacture remdesivir, which each company has by way of their raw material? What is the production capacity? What is the production capacity of each company? In how many days, how many remdesivir drugs will be made available, etc., etc., etc. So, my lord, that is something, my lord, which is avoidable.
That is micromanagement of the government function.
Well, your lordships have always, my lord,
That will never interfere with it. We can't ask you how a district is to be administered, how your collective could function. But suppose particular function is entrusted to the governor, the honorable governor, and if for years together he withholds it, will that also be beyond the scope of judicial review of this court?
my lord, I would say
when this court has set aside the constitutional amendment itself, which had taken away the powers of judicial review, that no amendment should be called in question by this court. It has been found to be hitting at the basic structure of the Constitution. So, and with the judgment or with those judgments, can we say that everything, however the highest constitutional authority may be, if it does not act, still the court would be powerless?
No, my lord. My argument, please do not misunderstand. My argument is not that the court is powerless. I am on justiciability. My lord, there is difference. There can be a power.
No, assent is given, not given. reasons, we may not go into that as to whether the president was justified in giving the assent, as to why he has given the assent, as to why the governor has given the assent. But suppose if an act passed by a competent legislature, if the honorable governor only sits over it, it could still be the courts.
Yes, I'll answer that, my lord, in two ways. First of all, your lordships would not decide whether there is any justiciable power in your the lordship or not based upon an extreme situation, my lord, which may arise. That is my first answer. And second,
Like you said yesterday, the hard cases lay down a bad law.
bad law.
And my learned brother said that hard cases lay down a good law.
Hard cases always lay down a bad law, my lord.
No.
No, no.
Not at all.
No such rule.
Lord,
They will agree with me and disagree with you.
Mr. Hari Vishnu Kamath agrees with
no,
Mr. Vikramnath.
my lord, he is a very respected person, my lord, but, Lord, this is
In a lighter vein.
on the lighter vein, my lord, but this is like, my lord, a candidate celebrating based only on the Ruzan coming in the morning, my lord, and distributing sweets. That's what, my lord, the other candidate would hope, that these are only Ruzan and not the real picture. So, my lord, your lordships would, my lord, in that case, my lord, even if the governor sits on the bill, the solution does not lie here. The solution lies elsewhere.
Where?
Solution lies in
Where,
the
where?
political sphere. These are all political decisions. Such cases do happen, and such cases are, my lord, solved through that democratic process. Lord, it is wrong to believe that there can be circumstances where every other organ would fail, and therefore the only available organ would be this organ. Lord, this organ has protected fundamental rights, and your lordships are custodian of the constitution, no dispute on that. But there are certain problems which are, my lord, not solvable by the judiciary. They are to be solved, my lord, by political democratic process. When such a thing happens, my lord, we have to expect and accept that there are constitutional functionaries who are responsible and responsive, because they are answerable to the people every day and at least every 5 years. In a situation like
Governor
this,
is not answerable to anyone.
pardon me?
The honorable governor is not answerable.
Governor, my lord, I'll answer that. I'll answer that immediately. The governor is the most vulnerable office. He can be removed without anything else. My lord, the moment the chief minister goes to the prime minister or the president and look at the facts of this case, this is what has happened, and such things do happen. That when governor sits over it, my lord, for good reasons, bad reasons, no reason, whatever, then political process takes over. And governor can be called back. Governor can be, some other person can go as a governor. Why not, my lord? And why can we not trust other constitutional functionaries? It's a matter of, my lord, the chief minister talking to the other constitutional functionaries that we are facing a constitutional problem. My lord, whenever something happens, my lord, in the judiciary, I'm not giving, my lord, a comparative example. My lord, the system takes care of it. There is an inbuilt system, my lord. Every problem does not come here on the judicial side. Your lordship takes a decision on the administrative side. So every problem is not solvable under Article 32 or 226 and thereafter 136. There are problems, my lord, under, I'm sorry.
Solicitor, the constitutional immunity to some extent is clearly worded in what advice given by the governor. Polycentricity, decisions involved in such a decision making. Why an assent is given, why a withhold has taken place, and why he refers it to the president for his opinion with a message. All these stand on one footing, and there is a constitutional immunity provided to all those. But we are actually today in this case referring to the procedure prescribed, which stands on a completely different footing. As regards the procedure, where is the constitutional immunity?
There is no immunity.
Number two,
I'm sorry.
it is exactly in this very context that Kesare hymn, what you have read,
Yes.
they drew the distinction, saying that whether there is no question of deciding the validity of an assent there, but the whether it was with respect to one part of it, another part of it, to examine it. They will look into it, is what they said.
That, my lord,
Therefore, an inquiry which is to be made whether the constitutional process, as Honorable Chief Justice has said, constitutional process of granting, not granting, or referring not being done, to what extent any kind of an immunity applies unendingly is the question.
my lord,
So we are not on the merits.
I bow down, my lord. I have understood the question. No, first of all, I am not basing my argument on any immunity. No, there is no immunity from judicial adjudication of any dispute except those issues which are not justiciable. I am not saying, my lord, immunity. For example, governor takes the decision of 356. Your lordships have even hailed such decisions to be mala fide in Bihar case. In case of Bihar, your lordships were, my lord, Butta Singh. But court said that he was acting mala fide. He is not immune.
He didn't use that expression immune. We are substitute it with judicial review.
My lord, I am putting it slightly differently, my lord, not even judicial review, justiciability.
Okay, put it in, replace it with justiciability.
Yes.
Then answer it.
Yes, my lord, justiciability, my lord.
Not.
Well, justiciability,
Can
my
there be a
lord, flows.
constitutional logjam then? Can there be a logjam?
My lord,
You are saying that the only way to answer it is through political process.
my lord, every logjam may not have a problem, may not have a solution with the judiciary. My lord. I'm with profound respect, kindly don't take this as an arrogant way of, my lord, putting it. I'm saying constitutionally, every problem may not have solution before the court. There are several problems where the problems will have to be sorted out as per the constitutionally prescribed democratic political process. And the court would be, my lord, holding its hands, my lord, saying that it is non-justiciable. We do not have any standards by which.
Our powers under 356 are for a temporary period. The president rules cannot be.
It can't be.
Then there are inbuilt safeguards.
Correct, man.
Within a limited period, it has to be placed before both the houses of the parliament.
Correct, man.
Then, if there is a dissolution, then
Within
after 6 months, so in under 200, if we hold that the Honorable Governor has an unlimited power to withhold for time immemorial.
I'm just allow me to make the distinction. Article
Then
3.
what is the safeguard for a duly elected legislature? Suppose a legislature which is elected by, say, 2/3 majority unanimously passes a bill. And we were giving example yesterday that if it is repugnant with the Central Act, then he may withhold it, or for some other reason, national security, so and so. If that be so, then if he doesn't exercise the proviso, it will be making the legislature totally defunct. The persons who are elected from that state, and if such a, it is not as if such a act is repugnant, then it is always subject to challenge. Or if it is contrary to.
May I answer? May I answer? Well, 356 is an executive power. It's not a legislative power, first of all. And therefore, my lord, there is
To be ratified by the legislature, central legislature.
no, correct, my lord. But that's not the question here, my lord, is the decision taken in exercise of executive power under 356 is subject matter of judicial review. My lord, again, my lord, your lordship's concern is a concern that what happens, but the answer is this forum is not the solution. The solution is either amendment of the constitution, and till that happens, the political process, and such process does take place. Every state does not take a confrontation position. My lord, they do, my lord, exercise their my lord, diplomatic options, meeting, my lord, the constitutional functionaries. They persuade, my lord, discuss, debate. If there is some gap between one thinking and another, they try to bridge the gap, and ultimately the problems are solved. Your lordships are not flooded with state government saying that my bills are pending. Therefore, I am, my lord, repeatedly cautioning, my lord, not to examine the matter based upon some extraordinary or exceptional situations. But now, my lord, I'll again come back to, my lord, page 259, my lord. State of Rajasthan versus Ramesh Chandra Mundra. Because here again, my lord, we would be creating a constitutional hierarchy that ultimately every problem will, the buck will stop here only, or for every problem in the country. Which is not, my lord, in my respectful submission, my lord, the real heart and soul of the separation of powers. Some problems are problem of a nature where the solution cannot be here. My lord, please come to, my lord, page 260. My lord, Kalpana Mehta. Lord, it again, my lord, talks of the separation of power. My lord, I'll not repeat it, my lord. I may not repeat it. Please come to, my lord, 264. And I'll just read two paragraphs and, my lord, move on. Lord, I have already pointed out that there are certain core functions. Core functions. My lord, there are, for example, governor exercises several powers. There are certain functions which are core constitutional functions in the nature of a legislative function. My lord, there the doctrine of separation of powers, my lord. My lord, the problems, I kindly pardon me for giving this, my lord, example. It may not be a comparable example also. My lord, Supreme Court decides 100 cases, hypothetically, my lord, per month. There are several cases where they are changed in the curative jurisdiction. There is a possibility that even after curative decision, jurisdiction being exercised, some may feel that still we have not got justice. Somewhere, something will have to stop. The buck will have to stop somewhere. The justiciability argument being met with that what happens if this situation arises is, my lord, in my respectful submission, my lord, ignores an argument that in every sphere of the constitutionally framed three organs, my lord, there are some issues where buck will have to stop somewhere. It need not be, my lord, it need not reach here, my lord. I'm sorry, my lord. I'm trying to phrase it the way it is possible. Lord, now kindly see, my lord. I'll skip, my lord, the rest of the things. And please come to, my lord, Aravalli Golf Club. My lord, I'm now on, my lord, other directions which are given 3 months period, give reasons. Lord, the Tamil Nadu judgment, the 3 months time fix, give reasons, and deemed assent. I'll come to, my lord, last point is deemed assent, whether there can be any conceptual concept of a deemed assent or not. And I have also enlisted the provisions where wherever the constitution stipulated that in absence of a particular act, something will be deemed, the constitution has provided. My lord, there is one beautiful passage, my lord, in Aravalli Golf Club versus Chendarhas. My lord, please see, my lord, the highlighted part only. Page 272.
270.
272.
The deem, opposition on deem?
No, no, my lord. Justiciability.
That's true.
Lord, restraint, judicial restraint, that every problem need not be solution here. They, my lord, they have used, my lord, one very popular statement of Justice Cardozo. Judges must exercise judicial restraint. Your lordship, Simon. Judges must exercise judicial restraint and must not encroach into the executive or legislative domain. Vide so and so. Under our constitution, the legislature, the executive and the judiciary all have their own broad spheres of operation. Ordinarily, it is not proper for any of these three organs of the state to encroach upon the domain of another. Otherwise, the delicate balance in the constitution will be upset and there will be a reaction. Judges must know their limits. I'm sorry, Mala, I'm reading the judgment.
Yes, yes, yes.
Must
You can read it loudly, no difficulty.
Why you feel sensitive? If you don't have
Judges
to, you
must
don't have.
know their limits.
Yeah, we also say that whenever a petition comes before us,
Your lordships have always, my lord,
that it
seen
is
the
the-
separation of power is, my lord, kept in.
yeah, whenever we don't want to name the petitioners, we show such direction to the Union of India to frame this law. We always say that it is within the domain of the legislature, it is within the domain of the executive.
Serial litigators, my lord, where we, as I say.
Something is done and the first petitions are filed with 2 or 3 pages, and so therefore,
Yes, my lord, so that the reported judgment,
so therefore the then Chief Justice came with this policy in re so and so.
Ray so and so.
Otherwise,
But that was suggested by me, that because there used to be a fight, that mine is filed first, but his petition is registered first by the registry. So, so therefore I suggested that instead that it should be Ray so and so. The judges must know their limits and must not try to run the government. They have modesty. My lord, kindly ignore it. 21. The
no,
theory
you
of
can read that. No, don't.
The theory of separation of powers, first propounded by the French thinker Montesquieu in his book The Spirit of Laws, broadly holds the fill in India too. In chapter 11 of his book, The Spirit of Laws, my lord, I can skip Montesquieu. Kindly turn the page over, my lords. I'm sorry, my lords. My lord, page 274, para 30. Para 30, your lordships, my lords.
Yes.
The justification often given for judicial encroachment into the domain of the executive or legislature is that other two organs are not doing their jobs properly. Even assuming this so, the same allegation can then be made against the judiciary too, because there are cases pending in courts for half a century, as pointed out by this court in so and so. If the legislature or the executive are not functioning properly, it is for the people to correct the defects by exercising their franchise properly in the next election and voting for candidates who will fulfill their expectations, or by other lawful methods, that is, peaceful demonstrations. The remedy is not in the judiciary taking over the legislative or executive functions, because that will not only violate the delicate balance of power enshrined in the Constitution, but also the judiciary has neither the expertise nor the resources to perform such functions. Well, kindly turn the page, para 35. The constitutional trade-off for independence is that judges must restrain themselves from the areas reserved to other separate branches. Thus, judicial restraint complements the twin overarching values of the independence of judiciary and the separation of powers. In Lochner versus so-and-so, Mr. Justice Holmes, in dissenting judgment, criticized the majority of the court becoming a super legislature by inventing a liberty of contract theory, thereby enforcing in particular laissez-faire economic philosophy. My lord, kindly skip some my lord, part. In the nature of judicial process, Justice Cardozo remarked, and my lord, this, my lord, in my respectful submission, has withstood the test of time and is being quoted often. Justice Cardozo remarked, the judge is not a knight errant roaming at will in his pursuit of his own ideal of beauty and goodness. My lord, in Maratha reservation, my lord, also this is cited. My lord, knight errant, my lord, is kind of it's a fictional character which used to roam around at night, and whatever he thought is improper or illegal in the society,
Robin Hood.
he would correct it. So therefore, they say that this is something which should not be done. My lord, kindly skip the pages, my lord. Page 282. Lord, one organ of state cannot arrogate to itself the functions of another organ. My lord, this is, my lord, when we say if you don't do it within a particular period, there would be a deemed assent, or we would examine whether you had justification of not doing it in a particular way, not doing it on a particular time, etc., my lord, would be violative of, my lord, separation of
Then
powers.
para 38 also.
Para, my lord, 353.
38, page 275.
Oh, I'm sorry.
Moral of the story.
Page 27. I'm sorry. Para 38. The moral of this story is that the judiciary does not exercise restraint and overstretch its limits. There is bound to be reaction from politicians and others. The politician, I avoid it. The politicians will then.
Why avoid it? It's in a print. Yes. It's in a print.
Lord, sometimes, Lord, politicians
Fairly because Mr. Sibal and Mr. Dr. Singhi are here, it doesn't mean that we shouldn't read that.
No, Lord, they're respectable politicians, Lord.
So they are in the real capacity.
No, even Mr. Wilson is here.
Yeah,
Was
Mr. Wilson is not to be
And,
seen.
um,
Mr. Reddy is also
Mr.
there.
Reddy is here, my lord. We have 3
The
MPs.
morning he was remarking, my lord, when he was mentioning about the parliamentarians, if Dr. Singhvi would be here when Wilson was there would have been 4 of us in a row.
And despite the parliament being in session, 4 of them are here.
That is how Parliament is adjourned now.
Cyanide.
On the lighter side.
So the moral of the story is,
More, let it, your lordships have read it. Why? I'll read, but there is nothing. The moral of the story is that if the judiciary does not
May I
exercise.
just interrupt for 30 seconds? Because there is this about this parliament and this. Because Mr. Jetli and I were coming out of the house, and Mr. Yechuri was also coming out. He had just given a speech in parliament asking for a law to prohibit doctors, lawyers, chartered accountants, and anybody else to be MP. So when we came out, both of us spontaneously told him, we said, Sitaram, you want parliament to be a community of unemployed and unemployables. This actually happened with us, and all 3 of us are together.
Lord, I was on page 282, but please come to page 283. Lord, State of Rajasthan versus Union of India. Lord, this is a 7-judge bench judgment, my lord.
Mumbai total threat. Mumbai.
February के अभी हम cover
But this is precursor to Bomai. Bomai I will not read. I'll just paraphrase why your lordships would not rely upon Bomai, though Tamil Nadu relies upon Bomai. Just a bold part, but it cannot assume unto itself the powers of constitution lodges elsewhere or undertake tasks entrusted by the constitution to other departments of the state which may be better equipped to perform them. The scrupulously discharged duties of all guardians of the Constitution include the duty not to transgress the limitations of their own constitutionally circumscribed powers by trespassing into what is properly the domain of other constitutional organs. Questions of political wisdom or executive policy only could not be subjected to judicial control. No doubt, executive policy must also be subordinated to constitutionally sanctioned purposes. It has its sphere and limitations, but so long as it operates within that sphere, its operations are immune from judicial interference. This is also a part of the doctrine of rough separation of powers under the supremacy of constitution repeatedly propounded by this court, and to which the court unswearingly adheres even when its views differ or change on the correct interpretation of a particular constitutional provision. Then bottom, a scrupulous adherence to this scheme is necessary for the smooth operation of our constitutional mechanism of checks and balances. It implies due respect for and confidence in each organ of our republic by the other two. My lord, particularly when, my lord, we are dealing with the highest constitutional functionaries of coordinate organs, my lord, in their constitutional capacity, my lord, not in their executive capacity, in their plenary power, which is legislative in nature, my lord. My lord, similar are other judgments, my lord. I am not troubling your lordships with, my lord, may be treated as read, my lord. Lord, thereafter, my lord, I have said,
Even Bommai is not completely against you
no, it's not.
because
In fact,
even Reddy's judgment in fact
it says there are manageable standards.
specifies what are outside the ken of
Exactly, my lords. I'm grateful.
some portion.
I'm immensely grateful, my lords. My lord, my lord, I have said, restraint in exercise of judicial power in case of high constitutional functionary is a facet of separation of powers, which is a basic structure of the Constitution. And therefore, such restraint and non-justiciability should be read as a part of basic structure of the Constitution to respect the separation of powers. My lord, then page 285, that even when there are undisputed judicial review positions, my lord, that legislature, executive policy, etc., there are inbuilt self-imposed restrictions. My lord, judicial restraint is always a self-imposed restriction. My lord, now page 287. My lord, your lordships must have these judgments. I am not reading them. But world over, these are judgments from other jurisdictions.
But you always say that we should.
I am not reading them.
Should only follow our jurisdiction.
Yeah, absolutely. Well, therefore, I am not. I said that your lordships must have it, but without going into it, my lords. Lord, Thames cannot be more pious than Ganga, my lord. That is the or Mississippi for that matter. Petoma, my lord.
What is
Washington has Petoma. Anyway, my lord,
Krishna is.
In the concurring opinion
in some concurring opinion of Samsher Singh, my lords. Lord, now please come to 304. Lord, I'll not trouble your lordships because propositions are known. Lord, there are three judgments cited in Tamil Nadu case for the purpose of justiciability. First is Bommai case, as my Lord Justice Narasimha has said, my Lord, and I respectfully, my Lord, take that, my Lord, that there the Honorable Supreme Court came to a conclusion that there are judicially manageable standards. This was not a case of assent. Bommai was a case of 356. And therefore, it was an executive act and there were standards, whether you could have done it or you could not have done it. And therefore, the judicial review was exercised. My lord, I have quoted the relevant paragraphs of Justice Ahmadi, Justice Verma, Justice Yogeshwar Dayal, my lord, but I don't wish to read them. My lord, second judgment which is cited is, my lord, Manipur Tribunal. My lord, that 10th schedule. Lord, that again, my lord, Speaker is a tribunal and therefore there is no dispute that he is amenable to judicial review. He is not functioning inside the house or as a leader of the house while he discharging functions as a adjudicatory body under clause 6 of the 10th schedule. And another judgment, my lord, which is cited, which is relied upon by Tamil Nadu judgment, is Maruram and Perarivelam. If we can have judicial review over that function of the president, why not this? My lord, Maruram and Perarivelam were cases where the Honorable President exercised purely executive act of pardon, which is subject matter of judicial review. And it was a case of Article 21 of a citizen. It was not, my lord, a political question that way. Political, not in, my lord, any derogatory sense. Political questions means questions arising out of functioning of a functional democracy in a quasi-federal constitution. My lord, so these three judgments, my lord, would not lead to any conclusion that it is justiciable. My lord, Oyston Kaiser, my lord, in my respectful submission, holds the field. Then your lordships may, my lord, kindly come to Lord, page 321. Lord, 321, my lord, raises question number 9. Raise, my lord, which the Honorable President has, my lord, sought your lordship's advice, is this. Are the decisions, my lord, page 328, 321, sorry. Are the decisions of the governor and the president under Article 200 and Article 201 of the Constitution of India, respectively, justiciable at a stage anterior into the law coming into force? Meaning thereby, my lord, this is a subset that it is still at the stage of grant of assent, withholding of assent, returning the bill, etc., etc. Can someone come and say that this act under Article 200 and 201 is unconstitutional? My lord, please have a look at, my lord. Para 410, my lord. Lord, I would only read.
Act under 20. Under 200, there is no act, still at the bill stage. So only when the assent goes, the act, and then, of course, act is.
Then the bill can be challenged on all grounds possible. Pardon, my lord?
Exercise of 200.
Yes, yes, ma'am. Act capital A. Yes, yes, ma'am.
But if there is no decision, you have framed the question. Are the decisions of the governor and presiding president under Article 200 and Article 201 of the Constitution of India, respectively justiciable at the stage anterior into the law coming into force?
Yes, my lord. But law comes into force when
Assent is granted.
is granted. But before that, it should have been granted, should not have been granted, should not have been referred to the president, should not have been returned to the house. Because here, my lord, we have faced a case where at that stage, my lord, the court has said that assent is deemed to have been granted. Then this is possibly, my lord, for the, not possibly, 100%, first time where the act came into force with the assent granted by the Supreme Court of India. My lord, your lordships on this side and on that side have seen acts which starts with this bill having been assented to by the President or Governor of India with a order dated so and so. My lord, these acts in Tamil Nadu mentions in the Gazette the bill having been assented by the Supreme Court of India with a judgment dated so and so. The court has exercised its jurisdiction at a stage anterior to the law coming into force. That is, my lord. And only see, my lord, one para, my lord, 414. My lord, your lordships would now again go back to Quixote. Quixote judicial review is available. Correct, my lord? No dispute on that because speaker is a tribunal. Still, 5-judge bench in Kyoto says that no qui timate action is permissible. We can finally set it aside, but we can do nothing at an interim stage. My lord, please have a look at
It
this.
has been interpreted that any such order which prevents the speaker from exercising his powers would not be permissible, but any order by the court which enables the speaker to proceed further would be permissible.
Yes, yes, yes.
Camat has been interpreted in so many judgments.
Yes, yes, my lord. But my lord, point I am trying to make is that even where judicial review is undisputed, it is at a stage where the action is performed, the order is passed. Lord, please have a look for my satisfaction, page, my lord, 322, what my lord Quixote Holohan says, my lord, on this. Pela 110, only one para is, my lord, relevant.
Tamil Nadu was a reverse case, Mr. Solicitor. Here the complaint was that action is not being taken. That was completely reversal.
Correct, my lord. That is justiciability, whether court could have done something or not. Correct, my
No,
lord.
no, so, therefore,
My lord,
we,
this,
we are not in an appeal of the judgment.
I am not,
Suppose, what is in our minds from day one? If for 4 years,
my lord, that your lordships will have to remove while answering this question. My lord, your lordship's interpretation cannot be based upon one particular instance.
Honorable CJ is asking on hypothetical case. Let's suppose there is a, it's not in one state.
and you are saying that it's, at least I think we are having petitions from 2-3 states now.
Yes, yes.
Kerala, then
West Bengal.
West Bengal, then Punjab.
Yeah, I was missing you.
Yes.
I was.
How can he be missed?
You here? No, there are fixed seats.
No, you objected to his petition on Monday itself, so.
Yes, yes. And your lordship now knows why they were opposing reference to a 5-judge bench.
But then we said that whatever we decide here,
Certain.
will
I am
affect all these
that
matters.
was on the lighter side. Nothing to turn on the merits.
The fallacy of this,
But we quite appreciate whether a time-bound program could be issued such a 3 months, 1 month, and then deemed and all that. But consider a situation where the governor is bound to either way grant asset, but if for 4 years just sits for, then what happens to the democratic setup of the government? What happens to the will of 2/3 of the majority of the legislature of that state?
I would not, my lord, like to answer, my lord, answer the way I am going to answer. But suppose, my lord, the precedent, my lord, as I'm at the cost of repetition, is
We are not talking about honorable president, we are talking about the governor.
the governor. I'm giving an example of a president of India where a citizen approaches him that my trial is pending since 10 years and the sessions judge is not taking up the matter and my offense is punishable with only 7 years of imprisonment and my husband is in jail. Can inaction on part of the judiciary empower the president to declare him as having only undergone the sentence? It may not be a comparable example,
We don't
but
think
this is
there are
how separation of power.
Exactly.
This is how separation of power. This presupposes that every problem will have a solution only ultimately at the doors of this court. And political solutions or democratic solutions are no solutions. There are solutions, problems in functioning of the constitution where there may not be a solution necessarily by judicial adjudication. It's not necessary, my lord, to hypothetically believe that every solution.
No, we are not hypothetically believing it. We are having petitions at least from the 4 states.
I am saying something else, my lord, that necessarily presuppose a belief that ultimately we will have to solve every problem. My lord, and my respectful submission is there are problems where this may not be the only solution or this may not be the solution. That's my respectful submission. I'll proceed further.
like for example, how political executive came up with 10 schedule. It's not a court's invocation. That's what you said.
Yes, Parliament did it because there was a problem of ayaram, gayaram, as we say. Defection was rampant.
The preamble itself, preamble of the constitutional amendment itself begins with that problem.
Correct. So, my lord, some problems, the solution can come only from within the system. That is, my lord, the doctrine of separation of power. There are certain core legislative functions, there are certain core executive functions, there are certain core judicial functions. But at the moment executive tries to step in, the judicial domain, your lordships have restricted. And rightly so, on the ground of separation of powers. Well, that is how NJSC went. NJSC was declared illegal. The entire political spectrum of the country was on one page. Unanimous. It was passed unanimously, ratified by the 2/3 of the state, but your lordships protected the separation of powers. That no, one person also from the executive would not be a part of the collegium. Lord, respectful submission is, my lord, the separation of power is a balancing act which balances the constitution. And it will have to be a two-way street. Some issues are non-justiciable, but that's the respectful submission. My lord, kindly come to 324. Is it permissible for the court, my lord, please 324, and I'll just, my lord, orally argue, but I'm not reading it. Is it permissible for the courts, and this is a very, very important, my lord, question which the Honorable President wants your lordships as, my lord, guidance on. Is it permissible for the courts to undertake judicial adjudication over contents of a bill in any manner before it becomes law? My lord, why this question?
I
is
think,
there?
It is that question, it doesn't.
I'll
arise
tell
as
your
law.
lordships why it has arisen. What is, my lord, the scheme of the constitution? The governor assents the bill, withholds the bill, or refers it to the president. Forget two options. Forget fourth option. He refers it to the president. The question has arisen where there is a two-judge bench judgment which says that it is prudent for the president, before granting assent, to make a reference under Article 143 of the Constitution to this court, because the question of repugnancy is a legal question. Meaning thereby, the president will come before your lordships by way of a reference that I have received these many bills from the state. Kindly take that direction. And it is otherwise imprudent for me, as the Supreme Court has said, to take decision on my own, and therefore I am now requesting you to tell me whether it is repugnant or not. It proceeds on two fundamentally flawed assumptions. A, the Honorable President, or in this case, Honorable President, is unable to decide for herself whether there is repugnancy or not. And number two, your lordships will examine the bill at a stage anterior to it being an act and decide whether there is any repugnancy or not. And if your lordship says no, you grant assent, then the president will grant an assent. My lord, do we have a dual structure where before granting assent to a bill, unless the president is herself or himself, my lord, is of the opinion that we need opinion. My lord, there are two or three references made on the bill that I would like the Honorable Supreme Court to examine and guide me. But otherwise, do we presume that president will not be able to, on her own, take a call, and therefore it is prudent that president in every case comes before the court under a reference with 143, my lord. I'll just read it, my lord. Your lordships need not open. Whenever in exercise of powers under Article 200 of the Constitution, a bill is reserved for consideration of the President on grounds of patent unconstitutionality, they are of such a nature so as to cause peril to the principles of representative democracy, the President must be guided by the fact that it is the constitutional courts which have been entrusted with the responsibility of adjudicating upon the questions of constitutionality and legality of an executive or legislative action. Therefore, as a measure of prudence, the president ought to make a reference to this court in exercise of his powers under Article 143 of the Constitution. So before the bill becomes an act,
This is, that's question number 12. We will examine that 12 in that context. But this issue relating to examining the bill at a bill stage is consequence of that question. This question doesn't stand on its own. This 12 doesn't stand on its own for the reason that nobody is asking the bill to be examined.
He has framed that question because of those observations.
This is it's coming before.
Before the president decides whether to grant assent or not.
Lord, kindly,
Lord,
kindly see. Lord, kindly see the, my lord, hazard of this. Well, kindly see the hazard.
I would readily agree with you that what should be the answer to that question.
Kindly see the hazard. Well, kindly see the hazard. I'll give a simple example, my lord, and there is no answer to that example.
I don't think that they would be opposing.
They would be, my lord. Let me place it. Let me place it. Lord, suppose
Civil as
they should,
authority was fine. Yeah.
well, they should not, because it's not
No, no.
A government or B government.
No, no, rewriting the constitution.
Yes, but the difficulty would be this. But if in every case the president as
Then we'll have to leave all other work and only devote ourselves to giving advice to the Honorable President under 143.5,
not the
145.3.
Lord, the difficulty would be, it would be a matter between your lordships and the president. There would not be anyone else. Your lordship says that no, there is no repugnancy.
No, but then under 145.3, we have to sit in a bench of 5 for giving that opinion.
Minimum 5. Minimum.
Minimum 5 years.
Well, minimum 5 is when the constitution was framed, where the total strength was 7 judges. It is that, my lord,
Now, you want to make it 21
At least.
difficulty is, my lord.
out of 34.
My lord, difficulty is, my lord, suppose the president comes before the honorable president, requests your lordship's opinion. Your lordship says either way that it is not repugnant. But I am a citizen of India. I am affected by that act. How do I challenge that act before the High Court? Because it is already got an approval from your lordships at a pre-act stage. Therefore, my lord, this question, I will not labor it, my lord, beyond the point. Then, my lord, may kindly see, and another point, my lord, which just for the purpose of stating, my lord, Article 143 is an enabling or empowering provision. It's not a
It's a discretion of
it's
the
a
president.
discretion. It's not a mandate.
Whether the president wants to seek
Justice.
advice or not, it is for her or him to decide.
Advice is always a discretion, whether to take advice.
Less the president making a power, more a justice doing power.
Yes,
That's what actually he.
it's an
invoked.
enabling provision, my lord.
Invoked that for the bench invoked that for doing justice.
ये तो question 8
Lord, that is what, my lord, I have page 327 is this question. I will not labor much on this. In page 327. In light of the constitutional scheme